and turn our meeting over to our zoning administrator, Joey Hargis.
Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of November the 18th, 2021. I'm Joey Hargis, Metro Zoning Administrator, and I'll be presenting the cases for review in today's hearing. I would ask this time if everyone would either silence or put on vibrate your cell phone so they don't interrupt today's proceedings today. That would be great. The procedure will be to introduce the case record as the Codes Administration has it. I'll do it on the wall here by means of a PowerPoint presentation. I'll go through photographs, site plans, things that were submitted. Once I'm done with my portion of the presentation, the appellant will come first to the table and present their case along with any parties in support. And then after the applicant goes, any folks in opposition come after them. The board in their rules provides applicants in cases without opposition 5 minutes to present their case to the board. I'll keep the time here on my iPhone, and I'll let you know at 3 minutes and at 1 minute how much time you have remaining. In cases with opposition, each side of a case, so not each speaker, but each side will have 10 minutes to present their case to the board. If you have multiple speakers, please work out who's speaking for how long before you get up here. And then the appellant in a case, should they wish to have a period of rebuttal after the opposition, will need to save a portion of their 10 minutes for rebuttal. We have one case today that is an item A appeal. The rules on that are a little bit different as far as sequence. In that case, I as zoning administrator will go first, present Codes' case and why I acted or why I made the decision that I made. Then we'll hear from the applicant in the case second, and then after that we'll hear from any other parties who wish to address the board. But in that case, the applicant, the other parties besides the zoning administrator, and myself as zoning administrator each get 10 minutes. The appellant will need to save some of their 10 minutes for rebuttal of those parties. So. All section numbers that are referred to today come directly from the Metropolitan Zoning Code, which applies to the entire jurisdiction of Metro government. This zoning code was adopted on January 1st, 1998, and I'll introduce and make a part of the record the zoning code, a copy of which is here at my desk. And I'll dispense from reading in any sections of the code unless appellants or zoning board members wish me to read those sections. The zoning code requires that these proceedings be taped. It's therefore imperative anyone wishing to address this board to come forward to the table. The microphone, as you see here, has a red ring around it. There's a button on the right-hand side of the microphone stand. Push that button one time. The red light will appear. Go ahead and present your testimony when you're done speaking if you'll push that button again just once, and it'll turn the microphone off. When you come up to the table, if you'll identify yourself and then make your presentation to the board. It should be noted that if anyone has presented false or misleading testimony to this board that may have affected this board's decision, any approval can be revoked at a later date by means of a show cause hearing. I'll go through all cases set for public hearing today, and the board will discuss and vote on those cases here in front of you. The board is vested with the power to act on these cases as outlined in section 1740-180 of the Metro Code of Law. The code requires that 4 members of the 7-member board be 4 members be present to constitute a quorum. Have a full complement of board today. All 7 members are present. It is necessary for you to obtain 4 affirmative votes in your favor for your case to be approved. In the unlikely event that you have a tie vote, let's say one of the members recuses themselves and there's only 6 members here in the case and we have a 3-3 vote, your case will stay on our agenda for the next 30 days. After that 30 days, if none of the members change their vote and the member who, we don't have that situation today, so I won't even cover it. Then failure to receive 4 affirmative votes within 30 days of this hearing shall be deemed denied by operation of law. Mr. Chairman, the appellant or any aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within 60 days of this hearing. After that time has elapsed, the board's decision is final and no further action may be taken. If you're an applicant and your case is granted today, it is necessary for you to pick up the permit for which you've applied. Again, follow up with the Codes Department beginning next week if your case is approved, and continue on obtaining whatever approvals you need to get your permit issued. Mr. Chairman, I submit that all cases were filed in proper order today. All appellants were notified as required by the code, and all affected property owners within 1,000 feet were notified by first-class mail. Before I proceed, the board does allow council members to address the board. If there are any council members present who wish to address the board. See none, Mr. Chairman. I don't see any with us. With mask, I may miss some faces there, but okay.
We're headed to consent.
Yeah, we'll go to the consent agenda. The board does have a consent agenda, and a board member, in this case the chairman, reviews the record for each case, and if in their opinion the applicant meets the criteria for the application they've requested and they feel that testimony would not alter the material facts, they recommend the case to the remainder of the board for approval. I'm going to call those cases into the record now that have been recommended by Chairman Taylor, and if you are here in opposition and only opposition to this case that I call, or these case numbers, please raise your hand, and we'll pull it from the consent agenda and hear it in its regular order. So the first case recommended for consent is case 2021-139, Catalyst Design Group and E3 Construction Services at 745 22nd North Court, requesting variances in street setback and height in RS5. The appellant's constructing a new single-family residence. Are there any parties present opposed to case 139 on 22nd Avenue North Court? I do have opposition present, so we'll hear that case in its regular order. The next case recommended for consent is case 2021-145. Brian Gaventaler, the owner and appellant of the property at 1813 Rosebank Avenue, requesting a variance from the street setbacks in R10. Are there any parties present opposed to case 145 on Rosebank? Mr. Chairman, I see none. This case is recommended for consent with the condition that the covered front porches to remain open. I have spoken with the applicant. They are agreeable to that condition. Okay. So that case is recommended for consent. The next case recommended for consent is case 2021-147, Lee Lunsford and Mason Harris. Mr. Harris is the owner of the property at 2809 Surrey Road, requesting a variance from the street setbacks in RS10 to construct an addition to the front of the residence. Are there any parties present for case 147 in opposition to that request? Mr. Chairman, I see none. That case is recommended for consent. The next case recommended for consent is case 2021-151, Green Hills Community Church, St. Paul Methodist Church, owner of the property at 5033 Hillsborough Pike, requesting a variance from the maximum allowable signage in RM15 to construct a second ground sign on the premises. Are there any parties present in opposition to case 151 on Hillsborough Pike? Mr. Chairman, I see no hands. This request is approved, elevation certain as submitted and as the site plan submitted. So any deviations from what had been submitted would have to come back and seek approval for that case. And Mr. Chairman, I think that's the case, the consent agenda. Did I miss any in that list? Okay.
All right. So we have a motion for the consent agenda. Is there a second? There's a motion and there's a second. Any discussion? And I know that.
Yeah, just know that I won't be voting on this one. Yeah.
Okay. Yeah. You said you needed to recuse from 145? All right, so we're going to take all of the consent items except for 145, and I'll if whoever seconded me, we'll amend that to say the consent agenda except 145. Any discussion? All in favor, raise your hand and say aye. That passes unanimously. Then I will move that case 145 be adopted as part of the consent agenda with Mr. Newton recusing himself. Any discussion on that case? All in favor of that say aye. Raise your hand. Any opposed? That passes 6-0 to 1. Okay.
Mr. Chairman, recapping for everyone here, case 145 is approved on consent. Cases 147 and 151 have also been approved. For those applicants, you are free to go. You're also free to hang out with us, too. No one ever takes me up on that. It's a shame. Okay, Mr. Chairman, the first case we'll call was case 2021-139, Catalyst Design Group, as the appellant E3 Construction Services, LLC, The owner of the property at 745 22nd Avenue North Court requesting variances in street setbacks and heights in the RS5 district. The appellant's building a single-family residence. The appellant's here, the opposition's here. Both parties will have 10 minutes. Mr. Chairman, before I go through the photographs, for the record, once I show the photographs, I'm going to step out. I represented the appellant in this case as a lawyer prior to my return to this case, so I'm going to ask Ashley to step over here and sort of take my chair and go through the photographs. But I will keep my comments only to here's what they're requesting, and then I'll step out. So,
All right.
yeah, if you don't mind. Mr. Chairman, again, my comments are strictly to the code, and here's what the request is. So, the variance requests that are before you are a request for street setback along Booker Street. Along the southern portion of the thing, the variance request is 2.75 feet off Booker. There is a variance to the maximum height allowable on this parcel. This parcel is undersized. It is a legal lot, but it is undersized for the zoning district, and there's a maximum height permitted at 35 feet. The appellants have built this residence at 38 feet. And this is the subject property. And then views of the site. I'm going to
And Joey, just when we were reviewing this case for consent, and again, sticking to just the facts of the case, because I know you are going to step out, but the logic for putting it on consent was the odd-shaped lot for the setback. There was a condition on this that, as part of the consent agenda, that the applicant build the sidewalks as shown on this site plan, because that is, to me, part of what you are pertaining to do. And then the height, because it's an odd-shaped lot, I was instructed by the zoning administrator that if this house had been built in the lot right next door, the height would be fine. That the height kicked in because of the size of the lot. And so that's the logic behind it going on consent, and certainly we'll hear the case, but I just wanted to make sure that that's kind of where our thought process was heading. Is that?
Mr. Chairman, that's correct.
Okay.
With that,
All right,
I'll recuse myself from this case and step out.
Are there any questions, I guess factual questions for the zoning administrator before we turn this over? And then is the applicant, okay, if you would come, and then I know you were, yes, sir, you can wait. And so I know that you all had a chance to talk. If you're still in opposition, then you still opposed to the case?
He said that he's going to move the building off my property. It's about 8-9 feet into the property.
Okay, well, so you have issues that we still need to talk about. All right, so we'll go ahead and hear. So if you would state your name and address, and then tell us your case for why you're here and what you'd like for us to do.
Thank you. My name is Philip Piercy. I'm with Callus Design Group, and I'm here to represent E3 Construction on this request. My address is 5100 Tennessee Avenue, 37209. In talking with the concerned neighbor, he owns the property just above this one. And so this project began as a renovation to an existing structure. And I guess try to make a long story short, since y'all appeared to be okay with the proposed plan. As the project progressed, they decided it was more than a renovation and it needed a new full permit as a new construction. The house had already been built to just basically everything except this came up with the framing inspection. So it's all wired, it's plumbed, all those were inspected and built. When that came up and trying to get a new full permit, they did a survey, determined that the structure was actually across on this gentleman's property next door slightly, and I think it was always known that it was in the setback. At this location, Booker Street has a 60-foot right-of-way, and although just a block away, the Booker Street is only a 50-foot right-of-way. And in addition to the right-of-way being wider, Booker Street is not constructed in the center of the right-of-way. It's offset quite a bit to the other side. So we were able to request abandonment of a portion of the right-of-way, and got 10 feet abandoned to provide more room on our side. But the plan here is to take this building, and it's, on the plan we submitted, it's shaded back where it's existingly located, and you can see it's right just across the neighbors, onto the neighbor's property. And the building will be jacked up and moved a few feet to bring it in compliance with this plan that we're here before you. So I believe his concern is, just want to make sure it gets moved, and that's the plan. Be glad to answer any questions, or I'll let him.
So on the site plan that we have, there's a light shaded gray line that does go over, and you can kind of barely see it here, but it says existing house and current construction location. That's the light line, and then the dark line is where you're going to move the home.
Right. And the gray line is where it's built now. That's where the original house was there that was started out as a renovation project.
Okay. And so how you do it's up to you. I'm not gonna, that's not our concern today, but it will be moved. You don't have a right, and you're acknowledging that you don't have a right to be on
Correct.
the neighbor's property, and that you will, and you're not asking for a setback variance there. I assume it's 5 feet or 3 feet.
It's 3 feet, and we're moving it to be compliant.
So you'll meet the legal setback on his property line. You're just asking for the setback that's shown in red, and then the height.
Now this is not the current, I just realized this is not the current plan I sent them. We had to shift this, and I can provide this plan we have. We made a revision because if you go back to that picture, it was discovered that the upper floor extends out over the picture of the house. The upper floor extends out. And so we shifted the house even more away from the neighbor so that upper floor didn't violate the 3-foot setback. And that made it closer to the Booker such that we requested to move the house closer to 22nd as well. So I don't know if y'all want this plan.
If you would please pass that one around. And then, did you have any issue with the sidewalk?
No, we plan on building the sidewalks as proposed on the plan.
Okay.
But so the request is reducing the 20-foot setback on 22nd Avenue to be 15. So we're shifting it closer to 22nd to also have a little more room on, because we were squeezing down on the Booker Street. Now, because the road is shifted across to the south, when you get out there in the field, you typically would see the right-of-way at the back of the sidewalk. And here, there'll be 4-foot additional room of right-of-way behind the sidewalk. So when you look at it in the field, it'll look like there's about 5 or 6 feet between the house and the building, and from what you would anticipate the right-of-way is, but it's actually going to be closer than that.
So you're going to have a curb,
4-foot grass strip.
4-foot grass strip, 5-foot sidewalk, and then you'll have also space.
Yeah, there'll be another 4 feet of grass to the right-of-way, and then.
So you'll have 13 feet from the curb to your property line, and then you'll have some additional space, or are you building right up to the property line?
It's where it sits on the ground, it's, I think, 2.5 feet, and because the upper floor extends out 1 foot, it will be 1.5 feet from the right-of-way on Booker.
But 2.5 on, so it'll be 15 feet from the curb, and.
Yeah.
Okay. And 10, or what's the 10 is the required setback,
Setback.
which would really make you have to be 23, and you're going to be somewhere close to 15.
Right.
Okay.
So I'll let him, unless y'all have other questions for me.
Any questions for the applicant? All right, thank you. And so we'll hear from the neighbor who's came in opposition, but just wants to. So, sir, if you would just press the button, make sure the red light turns on. Is that no at the base of the
Okay,
right
there
there?
it is.
And
Okay.
if you would state your name and address and why you came today to talk about this project.
My name is Paul Elton Bass. I'm here with my sister, Eleanor Sue Bass, and we were concerned about the property lines. We had a home fire, and my home was destroyed, and I was going to use my GI Bill in order to rebuild the home at that same property. And we're only concerned that we will be able to build it on our property. We love the fact that the home is there. It's a beautiful home. We just want to ensure that our property line is secure.
Okay, and so what you heard the applicant just a minute ago say that they're going to move this home,
Yes.
to be in compliance with the setback, on your side, on your property line. And so if they do that, you don't have an opposition
Not
to
at
the rest
all.
of the request?
Not at all.
Okay, and again, that's not something that's, we're not, he's not asking for any relief on your side of the property, so that's not part of what we're doing today. So I just want to make sure that was clear to everybody too.
Right.
So, okay. So if he does that, then you're okay.
We're perfectly fine with that.
All right, thank you. And is there any other questions for this gentleman? All right, Mr. Bass, thank you so much.
Okay, and can I say something
Yes, sir.
real quick? I'm so proud of one of your board members, and I don't know if I should call out names or anything, but coming in and seeing such good work being done by one of my students. I taught for 25 years at a place called MLK Magnet.
Yeah.
And
You're welcome to call out. You can say whatever
Mr.
you
Bass is
want
my
to.
seventh grade science teacher, so he's one of my favorites of all time, too.
All right.
so,
John Boy for
I'm
life.
so proud and happy, and thank you for doing such a good job at keeping up the excellence of our MLK students. Y'all, thank you very much.
All right.
Y'all have a good afternoon.
All right, thank you, sir.
And
All right.
this-
We'll hear back from the applicant.
I don't have anything else to say except just to confirm that we are moving it off his property and we'll respect that boundary.
Okay.
Can you just, with the new diagram that is
Yeah.
not, or site plan that's not shown up there, can you just confirm again the two requests?
The two requests, I think there's a setback on Booker reduced from 10 to 1.5 from up at the upper part. And on 22nd would be reducing the setback from 20 to 15. And then I think there's a secondary request about the height because the house does not fit, it doesn't meet the minimum size, then the height is limited to 35 feet. And our height is 38 from the finished floor to the highest peak. And I would think there's probably about a 3-foot foundation, so it may be 41 instead of 35, depending on how y'all measure the 35.
Okay. Any other questions? All right, we will close public hearing. It originally had it on consent for the reasons that we talked about, and I think it was a clarification issue too. So I'm happy to move that this be approved as presented with the amended site plan that was shown to us today based on the irregular shape of the lot and the height issue being an irregular lot also compared to the neighbor, meaning that the height issue would not have existed had it been in the neighbor's property. And that the expectation is that the house be moved to comply with the other side setback, which was not on the docket today, but that the neighbor came to talk about. The final condition is with the original consent agenda motion that was pulled, is that it is dependent upon the sidewalks being built as shown on the site plan.
Second.
Have a motion, have a second. Any other discussion? All in favor, say aye, raise your hand. Any opposed? That motion passes. Wish you both good luck. And we're glad that you did well after second grade.
Seventh grade.
Oh,
Yes,
seventh grade,
yes.
all right. Well, good. All right, next case. Oh, that's right, we got to get Joey back. All right, so the next case is 146. It's item A, as Joey mentioned a minute ago. We're going to first hear from the zoning administrator, who may also defer some explanation time to the Metro Legal representing the planning department's perspective on this case. We'll then hear from the appellant, and then after we hear from the appellant, we will hear from any other interested parties in this case, and the appellant will have time for rebuttal after that. I did see Councilman Pulley here. If you want to speak at any time after Joey and the introduction of the case, you can do that. Just raise your hand or come on up and let us know. All right, we're ready for you.
Okay. This case 2021-146. Mr. John Cooper is the appellant. George Moorhead, Moorhead Enterprises, LLC, the owner of property 4012 Hillsborough Pike. Again, this is an item A, appealing the zoning administrator's interpretation of the application of the height control and sky plane provisions within the Green Hills urban design overlay. The appellant has alleged the board would have jurisdiction under section 1740, 180, item A. As the appellants come forward, this case is a little different. I'll go first and present the situation and what came before you today. This case is before you based off an appeal from Mr. Cooper and his associates regarding the interpretation of the sky plane provisions within the UDO. The Green Hills Urban Design Overlay, in this case, applies the sky plane within the boundaries of the UDO. The urban design overlays are created and implemented by the planning department, and the provisions of the zoning code within those UDOs are enforced by that department. If this appeal comes to you by and through me, the urban design overlay is a part of the zoning ordinance. The planning department has submitted a memorandum, which I believe you've got a copy of. I know the appellants have a copy of, and I believe the other parties involved have a copy on its application to the here in this case. To my right is Mr. Alex Dickerson. He is Metropolitan Planning Department's attorney and is here to address any questions you might have of the planning department. Here, bear with me one second, Mr. Chairman. I apologize. When I stepped out, I wasn't able to queue up the You've received the letter from Mr. Cooper and his request. The planning's memo that you have before you, it particularly talks about that the Green Hills UDO states, our position is that the Green Hills UDO addresses specific height standards relating to the maximum height at the building setback line, and it lists pages within the UDO. It says, however, it does not address specific standards for height control planes at the rear property line when a building abuts an R or RS zoning district. Further, we recognize that specifically addresses the court case that specifically addresses the overall height, but do not think it clearly addresses the rear height control plane when abutting R and RS zoning. And with that, after reading the memorandum from Bob Lehman, the assistant director, I accept and agree with their interpretation, and thus this appeal ensued from Mr. Cooper. So with that, that's essentially my end of it. That's what this appeal is before you today. Councilman Pulley is present. The board does allow council members to speak out of turn if they wanted to. If they want to come first, want to wait to address the board at some point. But you're free to come up whenever you like, sir, to address the board. You do not have a time limit upon you. So we'll leave it. If you'd like to now, feel free to come forward.
I think, yeah, you just have to hit the button and it'll, there you go.
I'm on. Is that good? Okay. Thanks so much. Appreciate you all. Thank you for your service. This is not an easy job, and I appreciate you guys being willing to do it. From my understanding, this deals with an interpretation of the Green Hills UDO resulting from a court ruling rendered in a lawsuit filed by a neighborhood association about UDO interpretation around the development of the Veritas building just prior to my first term in office. I don't really think in my role it's appropriate for me to really weigh in on the legal issue. I'm not an attorney, and that's not what I'm here to do. I'll certainly leave that in the capable hands of the BZA commissioners to sort that out. I just want to let you know that I'm here mainly as a resource for you should you have any questions in your deliberation about anything that may have gone on in the community as it relates to this. So with that, I'll just leave it to you guys to hash out, and I'm here if you need me. Thank you.
Great, thank you.
All right, Mr. Chairman, that wraps up my portion of the appeal. I'll turn it over to.
And just Joey, just so, and I know we're going to talk a lot about, different zones that abut each other and that type of thing, but the crux of the argument is that the applicant would like to build taller in the back than the planning department has determined they're eligible for, and the planning department, because it administers the UDO, and therefore you have said you agree with the planning department and they can't build taller. I mean, isn't that ultimately what we're talking about? I mean, that's a practical implication of
Yes,
the appeal. Okay.
Yes, sir.
All right, so if we would introduce yourselves, although I think we know most of you. Welcome back to many of you, but just tell us your name and address and help us understand this as best we can in your 10 minutes,
And gentlemen,
not accounting your questions, our questions.
Before you begin, just over to your left, I'll keep the time here. I'll give you a notice at 5 minutes and at 3 and at 1. Again, just a reminder, you are entitled to a rebuttal. You're the only party that has one, so be sure to save some of the time you wish to save. And one of y'all look at me, I'll be happy to show you how much time I've got left. So, all right, thank you.
Good afternoon, board members. First, I just want to take the time to say thank you. I know how tiresome and exhausting this job can be, and so first off, thank you for your service to the residents of Davidson County. I would like to reserve 3 minutes of our time for rebuttal, so the goal is to hopefully get everything that we have to say here done in about 7 minutes. My name is Quan Poole. I'm an attorney. My address is 511 Union Street, Suite 1000. I, along with my co-counsel, Doug Sloan and John Cooper, represent Stokes Development, and they're seeking an interpretation of the height restrictions within the Green Hills Urban Design Overlay, or the UDO. And so, Chairman, to your question, I think it relates to height in the sense that the Planning Commission is saying that this 1.5 to 1 height control plane applies to the rear of the structure because it's a residential zoning district. And so that's what brings us here today. As Mr. Hargis alluded to, this is an item A appeal challenging his decision, but it's really the interpretation that was made by the Metro Planning Department. So the Metro Planning Department, similar to with SP zone districts, makes the initial interpretation, zoning interpretation within UDO districts. And though we're challenging Mr. Hargis's decision, it's really their decision that brings us here today. In the letter that Mr. Murphy sent out, I think he laid out the history of the case quite well. This really originated back in 2018 when a party reached out to the planning department about 4012 Hillsborough Pike. And at that time, the planning department made the determination or the interpretation that the height control plane would apply from the rear of that property due to some surrounding residential zone districts. Since that time, or since 2018, the Stokes development team has looked at this property and is trying to determine if that height control plane actually does apply, and we don't feel that it does. And so that interpretation was made, we don't feel, was with the help of this Tennessee Court of Appeals decision that you all have here in front of you today. And that is not at all a slight to the Metro Planning Department. I think they do a great job. I mean, I know firsthand the volume and the amount of work that goes to that department. And so every once in a while, there's going to be some misinterpretations or some misjudgments. But I think that's the purpose of an item A appeal. That's why we have this board, and that's why we're here before you all today. And so what we have is the Metro v. Green Hills Neighborhood Association case. And the central holding of that case is that the UDO guidelines, specifically section C1A, supplants 1712.060. And so what 1712, and that's Metro Code of Law 1712.060, what that provision states is that if you've got a non-residential district that shares a boundary with the residential district, this 1.5 to 1 height control plane will apply from the rear of that structure. What the court said in the Green Hills case, though, is that because of the UDO guidelines, which were adopted after that original ordinance and is more specific to a particular part of the county, supersedes or supplants the base zone district. And so, but in order for that to happen, there are two things that have to occur. One, the developer actually has to be using the UDO guidelines. So they have to be using the provisions that are laid out there in C1A. And so what that basically does is C1A establishes a maximum height for certain street frontages within the Green Hills UDO. Specifically in this case, it's Hillsborough Pike. And so what it states is that there's a 60-foot height maximum at the build to line. And so if you're using that specific section, that is going to supplant what you have here at 1712.060. The second thing that you have to be doing is utilizing the incentives which are laid out in the Green Hills UDO. And so what those incentives allow is for you to exceed that 60-foot maximum at the build to line as long as you are stepping back 10 feet. And so that, the net effect of that is that it creates the new height control plane. And so for each additional story over the 60-foot maximum, you're allowed to go up, but you have to step back 10 feet. And so as long as those two things are done, what the Court of Appeals said is that the height restrictions will not be imposed from that boundary line, from that rear property line. And then I'm going to read the incentive portion directly from the Green Hills UDO guidelines. And what that says is that, excuse me, whenever any incentive provisions in subsection B are incorporated into a mixed-use development, the following standards shall apply in addition to C1A. And it says exceptions to the building height. and it says, all floor space on any floor above the maximum height is a bonus space from the use of incentives, and each additional floor above the maximum building height is then set back at least 10 feet from the floor below it. So as long as you're doing that, you're allowed to go and continue to go up in height. And so the Green Hills UDO specifically states or specifies the manner in which the height is calculated from the Bill 2 line. And it specifies that the bonus incentives that are there in that UDO are what can be utilized to make that, to allow for that height. And so to take the interpretation that Southern Land and that the Metro Planning Department is asserting, it would essentially neutralize or make the bonus provision and the height exceptions within that UDO, it'd make them superfluous. And that was not the intent of the Metro Council when they adopted the Green Hills UDO. And then the next point that I want to talk about is in the letter from Mr. Murphy, who's here today. He represents Sutherland. He states that, stare decisis does not apply in this case. And so, basically what stare decisis is, I know the lawyers on the board are familiar with this. It's just a legal principle that once a court of competent jurisdiction rules on an item within their jurisdiction, that principle, that rule of law shall be followed in every subsequent case. In essence, it creates what people call a precedent. Once you set that precedent or that rule of law, it is to be followed in similar circumstances or in similar cases. What we have here is not something that's just similar. It's the exact same thing. And so what you have is the petitioners in that Green Hills case said that because that property was abutting a residential district, that the height restriction should be opposed from that line.
Let me ask you a question on that too, because I think the way I read Mr. Murphy's letter was that it wasn't the same because the court basically, I think it is, I'm saying what I think, so you correct me and tell me what, how you want me to think about it, or what I should think about it. But the way I read it was that the court said that it was, as you said, the exact same thing. But what I'm reading is that their opinion is the court got it wrong because 4,000 Hillsborough Pike didn't abut any of those districts, AG, AR2A, RS, RSA, R, MHP. It said all the property adjacent to the property located at 4,000 Hillsborough Pike are zoned either SCR or OR20. And in 4012 Hillsborough Pike, your property, the one you represent, it does abut an R10 district. And so they're saying that, I think that's the basis of the argument for stare decisis, if that's the way you say it. I'm not the lawyer. I thought that's what he was saying, that's why it doesn't apply, because the court basically, misquoted the zone. So tell me what I should be thinking about instead of that argument.
Well, and I think there are a couple of things there. I think the first thing that we'll say, and we sort of put it here on the board, what the court held was that, and this is specific language, that C1A...
Is that what's in yellow here that you gave us?
Right. C1A supplants 1712.060. It doesn't say that it works in conjunction with, it doesn't say you read those two together. It completely supplants it. And so the provisions that talk about AR2A or R or RS or RM zoning is in 1712.060. That section has already been supplanted by the Court of Appeals. But as it relates to the statement that the facts were wrong or incorrect, if you look on that same page, and if you're looking on the right-hand side of the page, I believe it's the third full paragraph down, what the court says is that the petitioners also contend that the plan did not comply with the SCR-based zoning district because the UDO did not change the standard of building height for Metro Code 1712.060. So what the court does here is it takes the contention of the parties and it analyzes that. It doesn't say these are the facts of this case. It says this is what the petitioner has argued. So the difference there being, it's not that the court are saying these are the facts of this case and I'm ruling on these facts. It takes the argument that the petitioner submitted in their brief and analyzes those. But even with that, the court says, and this is the very last line of that paragraph, this contention is without merit, right? So that fact scenario is the exact fact scenario that we have today, where the petitioner said, hey, we have a residentially zoned lot. This non-residential lot is abutting that, and so because of that, this height control plane should be imposed from that point. And as directly and as bluntly as you can put it, the court said this contention is without merit. And the reason it says that is because it goes on to say that the more specific standards, the ones that are varied based upon the Green Hills UDO, supplants everything that you see there in 1712-060, which is the very code section that the opposition is trying to use to say this 1.5 to 1 height control plane should apply from that location.
So what you're saying is even though the court or the petitioner's got it wrong and said it's residential, that actually helps you because the court ruled, if the court would have ruled on the actual facts, I'm not saying the court got it wrong, but apparently the facts were presented incorrectly. If the court would have ruled on the facts that were present in that case, you wouldn't have a ruling that was so squarely on point as this case.
Right. It is the exact fact pattern that we have here today. Right. And to that fact pattern, without any hesitation, the court said that the argument or the contention of the petitioners was without merit, and this is the reason why.
If I could add a little more color to this conversation, I was planning director at the time. Doug Sloan lived at 6354 Torrington Road. I was planning director at the time this went through and was involved in the lawsuit. And at the conclusion of the lawsuit regarding how you measure height, I met with the councilman and other members of the community about whether the UDO should be changed to alter this way that height was being measured. Understanding what the Court of Appeals decision said, understanding other properties in the area, should we review the UDO, bring it back before the community, and change it? And we had numerous community meetings on this very issue. So it's not as though Metro and the community didn't know that this was how this was interpreted. It was addressed in community meetings. There was never a consensus as to how to change the UDO, to change it in any way, to measure the height in a different manner, and so it remained the same.
So just help me understand just what happened. So the planning department now says that because there's no specific rear setback language in the UDO, that the base zoning rear setback would apply. That's where we're getting to the 1-to-1. Is that right? And then the case that you're citing says, well, no, that the UDO supplants the base zoning. And so how is rear setback addressed in the UDO then?
I mean, I think that is the interpretation that the planning department is using to try to get to where they want. Like they want the height control plane to apply from this scenario. So they're saying that, well, there's nothing in here specific to the rear setback.
But from your client's perspective, what would the control plane, or what would it look like in the rear?
The same setback that would apply at the ground floor would apply for the entire height of the building. The same required setbacks.
So the only step back is in the front.
Correct.
It's okay.
Right, that's the way the Green Hills UDO is currently written.
Thank you. And I know there's a lot of, I don't know, we got a lot of folks that know a lot more about it than I do, and I just want to make sure I understand exactly kind of what everybody's perspective is and what I should be thinking about, and I appreciate it. I'm sorry, you can continue unless there's other questions from the board at this.
Just proof perfect that lawyers can argue both sides on some things, and it's good to see you both, by the way.
Good to see you.
Good question. And so you're saying that with respect to the rear setback, say that again, the height control plane, the same height control plane applies?
So the same way that you would measure where the building has to set back off of the rear property line at the ground floor would be the way that you would measure the rest of the building going vertical. There's not a required step back from anywhere other than the front, off of the front street.
Because the UDO, I see it talks about the front building setback, but it doesn't talk about the rear building setback. So I think what your opposition is going to say is because it doesn't talk about a rear building setback, then the bulk regulations apply. So how would you, just jumping ahead, how would you respond to that?
We would handle it the exact same way the Court of Appeals handled it. And all we're asking is that this body interpret it the same way that the Court of Appeals said it should be interpreted.
But that wasn't really a rear setback case, right? I mean,
No, it absolutely was. It was, the goal of the petitioners was to reduce the height of the building by measuring both from the front and from the rear of the building. And so the petitioners argued to the court that there should be a rear step back measured. And then the court took up the petitioner's argument.
That's where they say petitioners argue that since the rear of the Green Hills property abuts a residential zone.
Correct.
Okay, so.
Correct.
Yeah.
And then take up our very scenario, and the court says, no, it doesn't.
And that's when they go on to say it supplants okay.
Yes, sir.
Right, it says petitioners argue that since the rear of the Green Hills property abuts a residential zone, the 60-foot height restriction in the UDO, and then it quotes, must be imposed from the boundary of the SCR district, which in this case is the rear property line of the development. And it says this contention is without merit. And so the main thing that we want to stress and that we have stressed is that this is unequivocal that the Green Hills UDO guidelines supplant was in 17-12-060. And then just the rarity of the set of facts that we have in front of the board today. Oftentimes when you're looking at how do you give effect to court precedent, you're using similar facts and saying because those facts are similar enough, that's going to also apply to the current case. But what you have in front of you is the exact same thing. It would be similar if the Court of Appeals had appealed or had considered another design overlay and said, and we were trying to extrapolate that from that urban design overlay to this one, but they analyzed the Green Hills UDO. And they didn't analyze the landscape buffer or the lot size or the land uses. They analyzed height on Hillsborough Pike, and that's what you have here today. So with those things, I'll conclude and reserve the remainder of my time for rebuttal.
Are there any other questions from the board?
Mr. Chairman, just for point of clarification, Mr. Cooper, I know you did not stated on the record. The board's precedent has been if there's something you wanted to address on rebuttal, go ahead and introduce yourself as party to the case as well.
Yes, I'm John Cooper with Spencer Fain Bone McAllister, representing Stoltz Development.
Thank you.
All right.
You'll have 3 minutes of rebuttal time remaining. Mr. Murphy, you have 10 minutes to present your side. Are there any other parties present besides Mr. Murphy who would like to address in this case at all? Mr. Murphy, seeing none, you've got full 10 minutes.
So I have the whole time. Thank you. Thank you, Mr. Hargis. Jim Murphy, 1600 Division Street, Nashville, on behalf of Southern Land. Since the board and the applicant have basically articulated my position pretty clearly, I'd like to ask the board members to look at two things that I have submitted, the Exhibit 1 and Exhibit 3. That's what I'm going to focus my discussion on here briefly, okay? So Exhibit 1 is...
Can you give me just a second?
Sure. It's near the back, but it's in front. One of them's in front of the... That's one of them. I'll tell you what. Why don't I pass this? If you'll let me, I'll pass this one around. be
Okay.
easier to
Well,
read.
I've got it now. That's what you're talking about.
Yeah, probably, because it probably didn't copy in color, but that's okay.
Is it possible to get that on the screen, or is it?
Okay. So I'll describe what I was trying to depict in this Exhibit 1 first. The 4,000 Hillsborough property is at the corner of Richard Jones and Hillsborough. It is surrounded on three sides by property zoned SCR. On the fourth side, it's adjacent to property zoned OR20. So there's no residentially zoned property to the rear of the 4,000 Hillsborough property. The nearest is a little bit to the south of there, 2011 Richard Jones Road, but it is not adjacent to the property boundary of 4,000 Hillsborough. Now, under the zoning code, outside the UDO, if you have property that's located in a commercially zoned district and you've got a step back, in certain zoning districts you have step backs, you have a structure that looks like, if you're adjacent to commercial on the rear, you have a structure that looks like option B on Exhibit 3. Okay, you step back from the front, and then on the rear, because you're adjacent to commercial property, or at least adjacent to the properties that are not subject to the height control plane, the rear structure can be basically, as Mr. Sloan described it, you can go up straight from the setback. On the other hand, if you're adjacent to residential property, you have this height control plane, which is what option A shows. And that's what they're contending is appropriate here, because their building adjoins residential property and not commercial property. It's our position that the UDO is clear that any standard that's not varied by the UDO is applicable in the UDO. So you have to have a specific provision in the UDO that varies the standard in order for it to be non-applicable. There is no specific language excluding the height control plane from residentially zoned property in the UDO. There is a separate provision that Mr. Poole cited that deals with the step back from the front. But there's nothing that deals with the step back or the setback or this height control plane from the rear. And so, first, these aren't identical cases, because in this case, you've got this property abuts residential property.
But let me stop you there. But that's exactly what, that's what the court, I understand, got it wrong, but the court says, I mean, it seems to me like the very argument you're making was made in this case, because the court got it wrong. Apparently it was commercial that was behind this property, but the petitioners in that case argued that you got to look at the rear setback because this is residential property behind it, and the court said this is without merit, and went on to say, look, the UDO supplants the bulk regulation.
Well, if the court got it wrong, then it's not a opinion that it's entitled to any weight, because the court can't issue hypothetical opinions, and this would be a hypothetical opinion. So,
But I get you there. I mean, doesn't that kind of, that interpretation is...
well, I think it's just a factual difference. This case doesn't have, the issue obviously is the council, in adopting the height control plane, wanted a different rule when you abut residential property than when you abut commercial property. And that's what I was explaining with my A and B exhibit. In many commercial districts where you're surrounded by commercial, you can build up to the property line, to the setback line on the rear, because there is no height control plane. But when you abut residential property, the council has imposed a higher standard. They want you to not they don't want you towering over residentially zoned property with your building. In our case, in the case with the Southern Land property at 4,000, that property didn't tower over any residential property. It didn't have any residential property around it. But here, it does. It towers over the property on the other side, on across the alley, that's zone residential. And so that's why why it's different, why the difference is significant, because the purpose of the height control plane there's not a height control plane for property that abut commercial property, office property. The council has determined having an option B right up against the property line doesn't matter, but it does when you have residential property, and that's why this standard is there. And again, there's nothing in the UDO that exempts property that adjoins residential property from having to comply with the height control plane. And so, again, we don't think the court case has any precedential value because the court had the facts wrong. The policy arguments are different because obviously you don't have a residential property to the rear like you do in this case. So for those reasons, we think that that the UDO didn't alter the height control from residential property.
So, I guess I was, it felt like to me when I was reading some of the briefs that there was maybe a typo in the court's argument or something and I keep going back to this sentence and I want to give you a chance to tell me that I should be thinking about something else or what, but the same one that Mr. Pepper just said, it says petitioners argue that since the rear of the Green Hills property abuts a residential zone, so it's not the court saying, hey, the petitioners are arguing this. I don't know what the petitioners argued or not. I mean, I don't have the transcript to know, and they may have argued that the 60-foot height restriction in the UDO must be imposed from the boundary. And then Mr. Pepper continued to read it too to say, well, that contingent's without merit. And so I guess that I'm not, is it wrong to read it, even if the court, if the petitioners, when they argued got it wrong or the court thought it was something different, the court's assuming that it's next to a residential zone and saying that even if it is, then so what? And so I guess
So as a matter of law, courts aren't supposed to assume facts that are not in evidence. And here, it's very clear that this property was never adjoining a residential property. So to the extent that the court said that, they were just wrong. And that means that that decision has no precedential value. So then the question becomes, is there a difference between these two properties? These cases, as Mr. Poole said, are exactly the same. And I've pointed out to you they're not, because in the 4000 Hillsborough case, it was surrounded on all four sides by either commercial or office zoning. And so under the base zoning, without the UDO, under the base zoning, there would not have ever been a height control plane around that property. Under the base zoning, there would have never been a height control plane around that property. Option B could have been built on that property. However, in this case, the facts aren't the same. This property has residential property to the rear. And so option A is what would have to apply if the UDO wasn't there. And the UDO only varies the front setback. It provides the step back as opposed to a setback and height control plane, which would be your typical structure, its typical regulatory scheme in a commercial district that had residential to the rear. And that's why you would have this structure shown in option A when commercial property abuts residential property. That's what's different in this case, is this case, this property does in fact abut residential property. It's not disputed. In the Southern Land case, it's hard to argue that it abutted residential property because it didn't, and the map shows it, and there's no dispute of that. Now, the fact that the petitioners confused in the Green Hills mixed use case, confused the confuse the Court of Appeals. Again, I can't explain why they did that, but they did. But that's just not the facts. The policy arguments that prompted the council to adopt the height control plan when you adjoin all these various residential zoning districts aren't applicable to the Hillsborough, the 4,000 Hillsborough property. It would have never had to have a height control plan. It could have always been developed with a rear that looks like option B. So for that reason, we contend that, the Court of Appeals decision doesn't provide any value, doesn't provide any precedent because the policy arguments are different. The factual bases are different. And so for that reason, we would request that you deny the item A appeal.
Do you have a question?
Making sure that I understand what I think your argument is, correct me, and I know you will very, very quickly.
Of course not.
But I understand. You're saying that the overall scheme that the Metro Council had a rational basis at law that was not implicitly eliminated by the later enacted.
That's correct. If the council had wanted to make the height control plan on the rear go away in the UDO, they could have put that in the UDO, and they didn't.
I know I do hasten, notwithstanding the council member being here, but he wasn't on the council at that point in time, so I just make that particular comment.
Any other questions at this point?
Thank you.
All right,
Thank you for the materials you did. They were very thorough, and we always appreciate that. You're welcome.
And so I have a question for our legal counsel, because I just want to hear from you kind of your summary of why the zoning administrator is correct, and how, in your opinion, the court case, how it applies and how it may not apply to this situation.
Sure. Alex Dickerson, Metro Legal. I'll just say that I think to understand why the board would struggle in the way it does with this, we have, on one hand, we have a case that seems to have pretty clear language. On the other hand, there's a limited precedential value that a court can make on issues that are not before it, and that's just a fact. The Metro Legal position, and I've spoken with Laura Fox, who actually argued the case in front of the Court of Appeals and was victorious, was that the board can still rule on this without that case being established precedent forbidding you to do that, because of the fact that they ruled on something that wasn't before them, wrong or right. And I think a court, if this comes back to a court, they would struggle with the same questions. They would say, okay, well, we have a case here that doesn't have the facts to set precedent, but is the implicit logic something that we should consider as persuasive authority? So, like I said, I think there are definitely strong arguments on both sides, but it's Metro Legal's position, at least, that you're not forbidden from reading in a rear sight plane by the court's decision.
Okay. That the misstatement here matters, that even because it was not before the court.
Yeah, the court got it wrong, and that can be used to eliminate the effect of that court's decision, or reduce it, however you want to look at it.
Any other questions for?
This was not reported in Southwestern. It was just a Westlaw opinion that we're looking at here. So this is not an official.
I'm not actually sure about that.
Most cases in Tennessee aren't reported. I understand, but I mean, but if we're talking presidential or value for binding us, I think in this particular instance, and if you're picking up, guys, I'm a little skeptical because I do see a difference between residential and commercial and what have you. I'll address that as you come forward, at least to help me a little bit.
Did you have any other questions for? Okay, and then did you have a question for this group?
I'm gonna let him go. I think Mr. Sloan has a pretty good feel for which direction I'm wanting him to
So let me first of all point out, just to highlight something that Mr. Dickerson just said. The Metro Legal Department defended the Planning Department, which I was the director of at the time, in this case, and won this case, saying that the height control plane shouldn't apply from the rear. So just to be clear, they were arguing the other side of this case at that time. And all of this came to light after that case. This case was hashed out in the community, at community meetings, by the people of Green Hills, the people who live in Green Hills, and the property owners in Green Hills. And when we discussed, should we change this so that the height control plane gets measured from the rear, we'd never got a consensus enough to actually go in and change the UDO. So it's not as though the community didn't know that it was not going to be measured from the rear where there was residential property. The court had spoken directly to that issue. And it's not as though that happened in the dark of night. We had community meetings on that very issue. And then no changes were made to the UDO to adjust that, to then make it apply from the rear.
Mr. Taylor, so exclusive of the implicit repeal issue that I'm struggling with, what I'm hearing is that notwithstanding that the facts may have been incorrect when the Court of Appeals reviewed it and when Chancellor Perkins looked at it, the basis, underlying facts they may have gotten wrong, you're asking us, notwithstanding that fact.
Well, actually, I'm saying that's a complete mischaracterization of what the court's done here, and really disrespectful of Judge Dinkins. Sorry, he knew what he was ruling on the petitioner's argument, not the facts of the case. He was ruling on the petitioner's argument, and the petitioners. I think if you go back and actually look at the case, what the petitioners were arguing was that it didn't matter whether the residential properties were contiguous or not. That was really their argument in the case. And that it should be measured, the height control plane should be measured from wherever the residential property is to this property. That was the argument that the petitioners were making at the time. I remember vividly. But the court took up that argument just to say it matters not. Because the UDO, in the way that the UDO says it's going to measure, UDO has a section that says this is how you measure height for property in the Green Hills UDO that has these characteristics, right? There are certain things, you have to have 3 different types of uses. There are some other things that you have to achieve to get to this bonus height. And what the court said is when you do that and you're covered by this UDO, the height from the residential property doesn't matter because the UDO has already said this is how you measure height. You don't measure height this way and then we're going to go into the code and cherry pick other things that we like and then we're going to add those in later. That's not how it works. The UDO controls how height's measured because it says in it this is how you measure height. And then it talks about from the front of the street.
To me, what the court did was that it took an argument and it said, even if this was the case, how much of a waste of judicial resources would it be to relitigate that? They said, even taking your argument, we don't think it applies here, but even if it was a budding residential neighborhood, that contention is without merit and the height control plane wouldn't even apply in that scenario because this section supplants 1712.060. And that's the thing, in listening to Mr. Murphy, he kept saying, well, if this wasn't in the UDO, if it wasn't in the UDO, if it was the base zoning district. But it's not the base zoning district. It is in the UDO, and these provisions, C1A, supplant and supersede what's in that base zoning district. The court couldn't have been more clear about that fact.
Isn't that then an advisory opinion on something that wasn't brought before them? I mean, you've got a skeptic, and I know you both are trying to get me to where you want me to be, but I'm having a hard time because I think Mr. Murphy made a pretty good argument. And I've asked the question about implicit repeal. And I've got two lights that just popped up on there, Mr. Cooper and Mr. Sloan. And help me with that, please, because
Okay.
I'm having a tough time with it, guys.
Well, so it wasn't a fact of the case. The facts about where the Southern Hills property existed in relationship to a residential property was part of the case. And the petitioner's desire to measure the height control plane from a property, not abutting, but a property within the community near it, it was actually just not even 100 feet away, there was a residential piece of property. That development as well backs up to Warfield. And so it is a fact of the case. It's part of the case that the petitioners wanted the court to measure the rear height control plane from that residential property. And the court took that very issue up. So I don't think it is advisory. I think that it is the law of the case, that it dealt with that very issue that the petitioners raised.
And that if there was a mistake, it was saying that the property abuts a residential zone. What you're saying is that the actual argument was that it was near a residential zone, and the control plane without the UDO would kind of look like this, and if you went over here to this property, then it might chop off the top here rather than here, that was the case, and the language says, it abuts, but you're saying that the testimony or the part of the trial, the court record, was making that argument that it should apply however close it impacts a residential zone.
You're stating the very thing that we spoke about, that the petitioners brought up, and that we spoke with within the planning department at the time. And I can't remember whether we got that clear during the community meetings, but exactly, whether it's abutting it so that the height control plane is immediately at the line, the property line, which would be the case if they were contiguous, or whether that neighborhood or the residentially zoned property were further away. That was the petitioner's argument. That was their point, that it should be measured somewhere along that line. And that's the very thing that the court addressed was, no, that doesn't matter.
Okay.
And if I could address Mr. Lawless's argument about, or question about the implicit repeal, what we are saying is that because you have these provisions in the UDO that are more specific under the rules of statutory construction, that supplants what is in the general zoning code, the general height plane, control plane provisions. Those don't apply here because we have the UDO. So it's not that we're saying that was repealed, we're just saying it doesn't apply. So it doesn't matter whether it's residential or commercial that it backs up to. The height control plane provisions in the regular zoning code have been supplanted. I think that's our argument.
I knew you would get it.
All right, any other questions?
So, to Mr. Cooper's last point, that statutory construction tells us that this would supplant the general bulk rules. I understand that. But it didn't say anything about the rear. So am I supposed to assume that because it didn't say anything about the rear, the same argument that he made earlier? I understand what you guys are saying, and I think it's compelling, the case that you gave us. But when I just think about what the other side said, I like to listen to both sides in my head before I reach a decision. Like, he made an argument that there's a policy argument that because in this particular case, forget the precedent that you showed me, just look in this case, because there are residentially zoned properties right behind it, does that not impact the height plane because the statute doesn't say anything about the rear, just calls out the front?
And that's correct, but that's what the court talks about is you have a section of the UDO that says this is how you measure height. You measure height at 60 feet. That's, I've forgotten what it is, 0 to 15 foot setback from the front, and then it's 60 feet up. You can go higher than that. The UDO says this. You can go higher than that if you measure from the front at the road in this manner. For every story you go up, go vertical, you have to go back 10 feet. That is how you measure height. It doesn't then say, and all other ways listed in the code that might apply. It doesn't. It says you measure height this way. in the UDO. And that is the very argument that the court made in their decision.
Any other questions?
Just a few more minutes. I think it might be worth pointing out that you're probably wondering, why is Southern Land bringing this argument in front of you against this building? Southern Land is the very company that built the tall building on the corner, but now they are suddenly concerned about tall buildings in Green Hills. But I would tell you that, as Mr. Murphy points out in his memo, Southern Land sought to purchase this property for that very reason, to build a tall building on, and walked away from it when they were told by the planning department that there would be a rear height control plane. And now the planning department is stuck with that position, having had a company walk away from developing it. That's why the truth of why you're looking at this again today. And what we would say is Southern Land should have known their own case. It was their case that set this precedent.
All right, any other questions? Anything else to add? All right, we will close the public hearing.
I just want to compliment both sides on their presentation today. It was really, really good.
Yeah, thank you.
Yeah,
So I'm only going to piss off 50% of the people.
Yeah. All right.
I'm going to turn this off so Mr. Lawless can go first.
I'll go first as a non-lawyer, and then Mr. Laws can tell me about how bad of a lawyer I would be if I was one, which...
Well, no, if you got some common sense, you'd probably be better than most of them.
Well, and that's exactly where this comes from, is my own common sense, which can be questioned at times, especially by my wife. But I have a hard time believing that any kind of UDO or code would not have any kind of rear control plane against a single-family residential house. And I know this site very well. You know, I've driven through that alley many times, and grew up not far from there. And I don't see how you could be, how any kind of overlay or policy could have in its intent and that it does not have any kind of height control plane on that rear side. And I also know very well that corner property is a very different character than the property in question. It doesn't abut residential. You have Royal Arms there not far, but it doesn't abut Royal Arms. It's got a fire station. It's got, you know, other commercial low-rise buildings around it right now. And this is a very different character of a site, in my opinion. So I'm having a hard time taking the appellant's case that the zoning administrator aired there.
I think Mr. Murphy's policy arguments, I think, are spot on. Let me say, I don't know that if I were writing this decision that the Court of Appeals of Tennessee wrote, that I would have come out the same way. I think I might have come out differently, but, you know, it's important that rules, that people out there have rules that they can follow and go by in court decisions that they can make important business decisions on and expensive business decisions on. And, I mean, we've got aware of my place in the metro government. I've got a chancellor from Davidson County who's ruled on this, and I think ruled in a way that fully supports the appellant's position. And then we've got 3 Court of Appeals judges who affirm that chancellor. Again, I don't know that, I mean, having a different height control plane for the rear makes perfect sense to me. I think you're spot on about that, Mr. Newton. But I've got a Court of Appeals decision here, and maybe they should have thought about it more. I don't know. Like I said, I think I may well have come out differently. I don't know that for sure, but there's certainly Mr. Murphy's arguments and Mr. Newton's are very persuasive, but I do think stare decisis is important and means something, and I've got a Court of Appeals decision that says the UDO supplants the height requirements in the bulk zoning regulations. And, you know, I get what happened there, which is the petitioners in that case got a fact wrong and made an argument and said, well, it's residential behind us. But I don't think that means you throw that opinion out and say, oh, there's this little fact that's wrong, and therefore, I mean, I think that was actually helped us out a lot because it tells us how the Court of Appeals interpreted this statute. So, and I think it's it's one of the more kind of complex things that we've dealt with on item A appeals, but that's the way I see it.
So when you're saying, and again, the supplant, it supplants, that's, you're reading that is entirely, and anything not mentioned is just not, doesn't count. So, I mean, if because the planning, and I'm just saying, the planning department's argument is, well, because sure it supplants it, but because rear's not mentioned, then rear goes back to base, and that this isn't precedent because it doesn't really abut a residential zone, and therefore it's really not an apple-to-apple issue, and that I think what was implied was that maybe the court should look at it again and decide, but
But I think it is apples to apples,
Yeah.
because I think what the court is presented there with someone
And so,
I'm not saying I wouldn't have come out differently on the decision, but it's.
So thank you, Mr. Pepper, for so succinctly summarizing kind of how I feel about it. I asked that direct question because that's what the planning department said. It was silent, but I do believe Chancellor Perkins and Judge Dinkins, and I was a clerk on the Court of Appeals for 2 years. I don't think that that one little sentence throws out this opinion. I think maybe somewhere either in the oral argument or somewhere in the briefs, the petitioners argued the point about residential, and the court was just addressing that argument. And they addressed it and said they felt like it was without merit because this sort of not overrode, that was really country. That was super country, that this essentially supplanted everything that was before it. And so I agree with Mr. Pepper, like from a policy perspective, and even Mr. Newton, if there's a residentially zoned home right behind this, policy would say we don't want something that large above it. But I also agree that we have businesses make decisions off of court decisions. It allows predictability. It allows them to plan what they want to do. And I think based off of this decision, the appellant was in a good position to think, well, based off of this decision, I can do this. And this is how they're going to measure it. So I agree with Mr. Pepper.
other thoughts?
I can't get over, we basically have an advisory opinion. And you got close, guys, but I in my mind right now, I still think Mr. Murphy is probably carrying the day with me. Now, I may lose, I'm just one of a whole bunch of people up here. But I also find it hard to believe that overriding policy really was, we're looking at that, I think, in part more so than the Court of Appeals. And courts get it wrong. I mean, I can go through a long litany of cases that all sorts of courts get wrong all the time. And you, as being clerk up in the Court of Appeals, probably saw it more than, I'm just old, so I've seen a bunch of them. But I can't get there. And I'm sorry, guys. I just cannot think that the Metro Council, when they conceived this and they transferred it and moved to the next level, I mean, they're not geniuses, but they would not think that an implicit, I think I've insulted you several times, Mr. Boyd, so, yeah, I mean, but what we're having requested is that there's an implicit repeal. And I can't get there, and I'm sorry. I've been wrong before, and I'll be wrong again, I'm sure, but this one, I just can't see it.
I mean, I feel like every time we hear a case that's about a UDO or something like that, I mean, at the end of the day, if it's not in the UDO, it reverts back to the base zoning. I mean, we've seen that over and over again with cases that have come before us. If it's not in the UDO, it reverts back to base. And so I don't see how that it could just cancel out the base zoning just because it's not in the UDO within this case.
And are there,
Joseph, he's got that.
So my rationale is in alignment with Mr. Newton as well. So I would think it would just revert back versus completely supplant it if it's not explicitly mentioned. So I think we're in alignment on that.
I guess it's my turn. Well, I was looking at the Title 17 and how the height control plane is defined. And it's interestingly not defined by rear, it's defined by street and by boundary with a residential district. So we spent a lot of time talking about rear and front and all, but I'm looking at it as there's a boundary with the residential district and the height control plane applies per what you said, just the bulk regulations, and it wasn't expressed in the UDO specifically. So I would be with in favor of the zoning administrator.
Motion. Mr. Chairman, I think this is where you come into play.
I will ask if there is a motion, and we can discuss the motion. I mean,
Okay.
you've heard enough folks express an opinion to know where the motion should go,
Can make it easy.
or a motion that might be more successful than another.
Well, I will move to uphold the zoning administrator.
I'll second.
Is there, and then is there a basis, because it.
I think you did get it right. I think there's no implicit, sorry. I don't, I think, and I know my fellow lawyers are going to say I'm an idiot, which, again, isn't the first time I've heard that probably today, and it won't be the last time I'll probably hear it when I get home. But I don't think there is an implicit revocation. I think we revert back to the base, and that in this instance, the zoning administrator got it right.
So can that be his motion and I'll second that? Does it work like that?
Well, that is a basis.
I will take that amendment.
Okay.
And then discussion on the motion. And I'll just say, I'm somewhat torn. I'm really, I guess the non-lawyer in me would love to have this go back to the court to address some of the issues that were addressed, and it may very well head that way, because I think that there were enough points raised to suggest that the appellant has, in my opinion, a strong point. And yet I do understand how the planning staff and planning department, legal department, and thus the zoning administrator come to their position too. And it feels a little technicality-ish, and those I don't necessarily like to have to, to do. It's a lot easier to say where should someone's garage go than to deal with questions like this. But
Or can they cut the tree down?
Yeah, exactly, but I definitely get the points that were made, and
Yeah, I
ready
mean,
to-
I keep coming back to the other case that we heard that was referenced, said that the boundary of a residential district didn't apply. And I think, but it also did not abut any residential district, so I can understand why the residential district would not apply in that case. But in this case, it does abut a residential zone, and therefore I don't see how it doesn't apply. I'll put it that way.
Well, and to me, if there are questions and it's not absolutely clear cut to someone, I would. My rule of thumb is sometimes, err on the side of, in this case, the zoning administrator that might, because of the interest of residential zoning, but yet also just me personally recognize that the appellant has a pretty strong case. And, it can go beyond this board and may very well, but so anyway, any other discussion on the motion? All right, we'll call the question. All in favor of the motion, raise your hand and say aye. Any opposed? That motion passes 5-2. Any and come back.
Applicant approached me at the break on case 2021-150, Mr. Snyder at 3106 Trevor Street. He has withdrawn his appeal. He is not going to proceed with that case. So that is case 150 at the bottom of page 3.
So and I think are there folks here for that case?
Case 150.
So well, and
I'll
I
talk
think
with you.
I know we had an appellant and some opposition. Can you just explain what withdrawing the case means?
Sure. That, by the applicant withdrawing the case, he is going to have to get those homes in compliance with the zoning code. So, all right. No problem.
All right. So then we will have the last case, case 149.
Get the screen back up. There we go. The final case today is case 2021-149. David Farrar is the appellant. CRP/WP Alta Metro Center owner LLC is the owner of the properties at 115 Great Circle Road, requesting a variance in height, size, and setback restrictions in the MUG district for ground sign. The appellant is erecting illuminated monument signs on the property. Referred to the board under section 1732-120. The appellant has alleged jurisdiction under section 1740-180, item B. Yep, the appellants are present here. After my presentation, I'll turn it over to you guys, and you're welcome to come forward if you'd like to now. Just have a seat, and I'll turn it over to you in just a moment. Mr. Chairman, as you can see, looking at the room, there are no other parties here concerned with the case today. All right, the subject property is located on the terminus of Great Circle Road in the Metro Center development. Has the property, I believe it's the property in red, but it's also the parcel to the west of that as well. Is that correct? Okay. And that may actually dispense with one of the variance requests before them today, based on the road frontage. This was the aerial photograph of the prior structures that was on the property before. Again, it is the parcel just west to the left as well. With that revelation, the variance request for the number of signs is withdrawn by staff. They are permitted, based on that road frontage, 2 signs we are counting these signs as duplicate signs. So just for the record, the variance on the number of signage is changing. The other variance is setback between these signs, the height of the signs will still be before you. The size requirement, I'm going to look up here in the table, that number will change. I will alter this in the break and get the correct square footage on there, because it is a factor based on how much road frontage they have. I think when this appeal was filed, we were just given the one parcel, so these numbers are computed off that, but I'll get you the right numbers here in just a minute. Long and short, this is the signage that is requested for you today, and how this zoning code, this section of the code for zoning code nerds was actually created before 1998. The sign code of the zoning code, like myself, was created, actually started in 94, was actually adopted in 96. It predates the rest of the code, and the rest of the code is kind of wrapped around the sign code. But we would take the words, in this case, Alta, and box those letters, as you see the display, how the sign company did that. That's how we would do that. The word Riverwalk, we would also do the same, and box that entire area, including the space between the letters. But if you look at the line that sort of zigzags between the two, I get my cursor there, see those? Each of those black spaces corresponds with the letter involved in there. So it's really, RI is sitting on a place, VE sitting on a place, so it's likewise as you see there. These are separate. We treat the word Alta and the word Riverwalk as separate signs under the zoning code. The location of those signage, if I read, gentlemen, if you'll correct me during your time, I believe they're here and here, where those are going. So that variance between the space between the two sign structures is 72 feet apart.
And Joey, didn't you say those were existing pylons from?
If I understand, and I want the applicant to address that, the structures that these letters will be mounted on, are they remainders of former steel on the property? What are you doing there?
I got this. They're designed to be remnant structures. So we are building them back new, but the architectural design and architectural style of this community is kind of river mill remnant, much like the Newhoff development just down the river.
Okay, and if you would, I'm sorry, Joey, were you done?
Just a couple quick photographs of the site upon my visit there the end of last week. This is at the end of Great Circle, and I'm looking west at the end and then turning toward the site. I believe those signs are going kind of in this area. Is that correct?
Yes, that's correct.
That's okay. And then some other views looking toward the river. And but that is all I have. I'll update the square footages here and get you an accurate reflection of their variance there.
All right, if you would just state your name, address, and tell us what you're trying to do.
Name is Jeb Puente, Jarvis Signs, 310 Madison Street in Madison, Tennessee. And we're here working with Andrew, with Wood Partners, to erect a sign for Alta Riverwalk.
Yeah, Andrew Steffens, 929 Gale Lane, Nashville, Tennessee. What he said, but is this our opportunity to just kind of speak? Yeah, okay, great.
Okay.
I'll kick us off. I've been building multifamily communities in Nashville for a decade, and Wood Partners, we really try to build into the context of the community and build great communities for people to live in that are moving to town or already live here. And with this design and this community, we, like I mentioned, we wanted to kind of aim at that historical river mill type feel, but obviously this site has challenges. One being that it's at the back of Metro Center at the southeast corner. There's very little vehicular traffic back there, and the pedestrian traffic is all on the greenway, which is on top of the river levee. So really the variance is a request to kind of help us get up and over the visibility and the river levee, which would otherwise block us, and then give us some visibility from the interstate and the river. As we all know, the Germantown area and moving north is developing, and that greenway really is going to continue to be activated more and more. So this is our attempt to help with that, and in doing so, we've worked with the council lady. We have a letter of recommendation from her. We worked with the Metro Center Homeowners or Business Owners Association, Wood Caldwell. We have a letter of support from them. Everybody's kind of on board because this is, our community is adjacent to the Greenway entrance. So everybody that is involved, all the stakeholders in the community really want us to open the door, so to speak, to Metro Center, to those that are going to use the Greenway. So that all kind of helps in putting more, architectural visibility on this specific site.
And who's your council lady?
Council Lady Toombs.
Okay.
I don't know if you guys have that. We have a letter from her that is, okay.
All right, any questions for the applicant? Anything else to add? All right, well.
Can we get that letter I didn't see that in the packet anywhere, so.
Oh, you get the council, letter from the council lady,
ladies.
if you could just hand that around so we can get that as part of the record, I don't.
So I have a question. So the hardship is the slope, the 20-foot slope, is that correct?
Yeah, so behind the property, you have basically the
Levee.
The levee right there behind, and so it's high enough that you can't really see anything.
Okay.
So if we do a sign low, it's basically something the ground you're not gonna see.
And I get why that would cause you to need a variance for the height. But
Yeah.
how does that cause you to need a variance for twice as much for the square footage of the sign?
At that point, you're at a certain height that if you keep the square footage small, it's gonna fall back to where you can't see it again. It's just gonna look like a speck in the sky. So if you do it a little bit taller, it also brings nice style to the building, and it all kind of comes together.
But
The scale of the monument or the remnants as well.
But we've also had cases where, in some ways, it's a unique sign. I mean, if this were, a Burger King or a Crystal, and it was all, a white backlit plastic, that was 90 inches by, or 70 feet, whatever this is, that's all one sign. I mean, you really have individual letters, and so to me, I think what we've looked at before is maybe the hardship is the type of sign warrants a different type of measuring standard.
Mm-hmm.
Is that?
Yeah, I mean, I think, going with the, if we were to do a lit up white Burger King style sign, we would lose the design intent.
Yeah. And nothing against Burger King, I'm just saying, it's just somebody,
Getting some free advertising.
No, I'm not making a case for one or the other, but
And this is part of
everybody got the image I was talking about.
We actually spend quite a bit of time on the branding, bringing
Yes.
in members of the community, and really what you're seeing, the Alta and Riverwalk, the font style, the scale, it's all the result of all that time spent kind of coming up with this community that fits within the fabric of the community, so.
Okay.
And your square footage looks a lot, but I mean, if you think about it, there's a lot of space, a lot of empty space around, so.
Right. Any other questions? Anything else to add? All right, we'll close the public hearing. Had I had the letter from the council lady and I had this rendering as part of the original submittal, I probably would have put it on consent agenda, but that's just my 2 cents on it, and I don't know how everybody else feels about it, but I think it's a pretty cool sign and meets the hardship.
So there's no opposition, these folks back here aren't?
No, nobody's here in opposition to this, right? Okay, no. So,
I'll make a motion that we approve, based on the hardship of the slope of the lot and the design of the sign, constituting a different kind of measurement requirement.
and then I'll second with the condition, with just the stated condition that the sign be substantially.
Without substantial change to what was presented.
Without substantial change to what they've
Correct,
presented.
yes, thank you.
Does it need to be some type of stipulation for illumination? Like, we don't want this thing lit up, right?
I think that's covered elsewhere in the sign code. Joey, is that right?
They are proposing an illuminated sign.
But can we, let me open the public hearing if there's no objection.
that's fine.
How do you plan to illuminate this? Is this going to be backlit, or is it going to be
It's
like
gonna
front lit?
face lit, but it'll be a soft glow. It's not like you're standing and looking at a white, bright, you know.
Very, very similar to the
Yeah.
other signage you see on the river downtown, on the Second
Just
Avenue.
okay, a facelift, but not the LED.
No.
I mean, it may
It's,
be all right.
it's a soft glow.
Is that acceptable?
Yeah,
Okay.
that's fine.
All right, we'll close public hearing again. Have a motion, have a second.
Yep.
Any other discussion, concerns, or additions? All right, all in favor of the motion, say aye, raise your hand. Any opposed? That motion passes. Good luck.
Thank you.
And with that, we're adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.